Well, hello everyone. My name's Emily Bowler, and I'm the Executive Director of the IBBA. And I am so excited today to be here to be able to introduce two very special panelists and the group BEEF, which is the Business Intermediary Education Foundation, which really is the sponsor of this webinar today, to talk to us about the M&A registration exemption, specifically at the state level. Where do we stand? What do we do moving forward? And what that looks like. Throughout the presentation, we're going to give some brief descriptions and walk through it, but we really do encourage you to submit questions. There's a lot going on throughout the states, and I encourage you to go ahead and enter in the chat or in the Q&A portion of that. The chat will be open, but if you have any questions throughout the presentation, please put them in the Q&A. That way we can look at those questions later on and make sure that we're covering all the information that's coming from you. If you would like to, just really quick, we were very curious where everybody's coming from today. So if you have a moment just to pop in the chat where you are and where you're located, I think that would be some great information for us to have as we continue through our presentation. With all that being said, all right, they're coming in. I see an Ohio person in here already with me. So with that being said, I am going to introduce our two panelists today. We have John Zak, who is the managing partner of IBG Business, who also is a pilot, also does all sorts of amazing stuff, charity work, and with that is also the chair of BEEF, and we're lucky to have him here with us today. Also, we have Shane Hansen from Warner Norcross and Judd LLP. And I thought this was interesting. I was looking up interesting facts about both of you. And I hear, Shane, that you were voted best lawyers in America, corporate law, securities, capital markets, law, and securities regulations from 2007 to 2025. So how lucky are we to have you here today to share your time and talents with us? So with that being said, that tongue twister today, I'm going to forward it to the BEEF slide and really let John share kind of all of his expertise and where we are today and all the great history with this organization. So with that, I leave it to you. And again, I encourage you to enter questions in the Q&A. Thanks for being
Hey,
here, John.
thanks very much, Emily. I really do appreciate it. Just as maybe a beginning, Business Intermediary Education Foundation, also known as BEEF, started in 2003. It was actually created by key leaders in the International Business Brokers Association. The reason it was created was they needed a conduit to work outside kind of the scope of what the IBBA was created to do. And it was supported by the M&A source and numerous other groups and individuals and professionals. The concept or the mission behind BEEF, if you will, was education, advocacy, community, and also partnerships. In other words, be able to work with different associations across the board to further our industry and develop relationships that were outside the scope of a single association. I'll go to the next slide, please. As you already received our great introduction by Emily, we have Shane and myself here today. I'm in Denver, and it's supposed to snow this afternoon and evening, so I'm joining the rest of the country and looking forward to a warm fire and a glass of red wine tonight. So I'll move on with that introduction. I would like to point out and shout out for Mike Ertl. Mike Ertl and I worked together for almost 20 years, and he passed en route to the M&A source to do a presentation with Shane Hansen when I happened to be out of the country. And Mike, probably if he didn't work every day on this endeavor, change registration or get an exemption for all of us in our industry, he definitely worked every week for close to 20 years. So he passed away May 19th this year, and I just wanted to give him a shout out. He contributed unbelievably to our industry. Thank you, Emily. So today's presentation, I'm going to try not to read everything, but there is kind of a CYA. It's educational. It's not legal advice, although we got an expert attorney here giving us opinions and ideas and things that we need to know about. The application of what is going on is complex. There's a lot of different elements involved. Now, I try to simplify things, and Shane tries to be very specific. So you'll get two different opinions and phraseology from both of us today, I'm sure. I am also licensed in security. I have a securities license and have had it for, oh, geez, almost 2 decades now, I think. But I felt that strong about our industry and this exemption that I have contributed and donated my time for almost 20 years now. So the big point, though, we want to keep addressing today is that we had a big home run in the federal government. We changed the Securities and Exchange Act. We changed it. Now, the Constitution says we also have to get the states in line. And I'll pass this on to Shane on the next slide to maybe talk a little bit about that.
Sounds good, John. The key takeaways for today, we're going to hit just a quick refresher and then move on to the real meat of this. But the federal law changed. It's actually an amendment to the Securities and Exchange Act, creating an exemption for M&A brokers. That's a defined term, so you want to read the definition to see who's covered and who's not. It applies in deals that are structured that involve securities. And the good news is that the very broad securities definition of a broker encompasses an M&A broker who is engaged in these purchase, sale, exchange, or reorganization of a target business. The target business has to be privately owned and has to meet certain size caps, but the key is that federal law does not, in this instance, preempt state law. So we change federal law. We are in the mode of now trying to change state laws. That can be by rulemaking, by order, or by lawmaking. And the good news is we've got 23 states so far that have adopted M&A specific exemptions that apply to M&A brokers using the same definition as in the federal statute. I just highlight that there are some other exemptions out there. Washington State, for example, exempts all private placements of securities, which is a bit of an anomaly, but they do. And so there's actually a total of 24 states where we have exemptions for private company M&A transactions involving securities. And importantly, we'll talk a little bit more as we move along, NASA, the North American Securities Administrators Association, this is the association or trade association, if you will, of state securities regulators. They adopted a model rule starting in 2014 and then freshening it in 2024. So we have a model state rule that has been blessed by the state securities regulators as an organization and available for adoption in various states. And we'll talk more about that. But another important takeaway here is that 17 states, and this is apart from securities regulation, 17 states regulate the profession of business brokerage under their real estate licensing laws. That's not going to be covered in this program, but it's important to note, and in fact, it can be useful when you're talking to state regulators or state legislators or the governor to say, hey, look, this is duplicative regulation. We're already regulated under real estate laws in 17 states, and you can be specific about that. But why does this matter is really the last bullet point here. If there's a requirement that you're registered, just like any licensed profession, if you don't have an exemption from that requirement, that means you are operating illegally. In other words, you're practicing a profession that you don't hold the appropriate qualifications for. And that simply translates quickly to the client, seller or buyer, either side, doesn't have to pay you if they don't want to. And that's where this issue usually comes up. It's not the regulators coming out after you. It's a disgruntled client or a competitor or could be a former disgruntled employee who wants to cause you trouble. And it's usually in your being able to collect a success fee after a transaction has been closed. So that's why this still matters, and it matters at the state level every bit as much as it does at the federal level.
Okay, just to expand upon it, because you just mentioned that. So is the downside only that we don't get paid if we're found in violation of a state law? Or
Well,
is there other downside to us?
Well, the downsides are primarily just as a practical matter, a risk analysis is that your compensation, including any recoupment of expenses already paid, are uncollectible. The regulators don't go out looking for unlicensed people. It really occurs when someone puts you on the radar of a regulator, and then they may conduct an investigation and to determine whether or not you should have been and are acting as an unlicensed professional. That'd be true for law, accounting, any profession that has a licensing regime. The regulators could bring enforcement actions, but I would say in practice, the issues primarily involve simply someone's unwilling to pay. You sue them to collect, and they raise as a defense to that collection effort that you weren't properly licensed. And that's pretty much a slam dunk for them.
And I've heard,
Regulators, they may pursue it, they may not. It's really very much, though, an economic issue. If you do get investigated, it'll cost a lot of money to defend yourself. But I would say in more common scenarios, it is someone who doesn't want to pay you.
yeah, I think it was Lynn Crick in Nevada who had close to, I think, $500,000 in legal fees involved, trying to defend his position.
And that
And
scenario, great example, John. That was a scenario where a father bought a business for his son. The son ran the business into the ground, and then dad wanted to get his money back. So he complained to the regulators in Nevada, who conducted a investigation incurring for him a lot of legal expenses. I think in the end they settled it, but it was not without a huge amount of pain and anxiety over the whole thing. But it's an example of where some disgruntled client, in particular, that example, complained to the regulators to put it on their radar.
if you're not compliant, do we create a put? In other words,
Well,
buyer
you
put
you
back to
can
the seller?
specifically in California. California has a really draconian solution to an unregistered broker, and that is that the broker can be forced to buy the securities that were sold by an unregistered broker dealer in California.
Wow.
Other states, it is more likely to come up in the context of the buyer who wants to be able to unwind the transaction, and so is going to claim that. Whether or not a court or a jury awards that kind of outcome is a question that would vary depending on the facts and circumstances. I wouldn't call it a put per se, but it can cause a lot of grief extending over many years and a lot of legal fees.
Doesn't sound like fun to me.
It's not.
Hmm.
And I'm a lawyer, but the last time I saw the inside of a courtroom was watching LA Law. I'm a securities lawyer. I try to keep people out of trouble, occasionally have to try to get them out of trouble. But if someone wants to sue somebody, I have colleagues who deal with that. So
You see. Well, moving on to the next slide. What does this exemption, what are the key points of this exemption?
yeah, so what we want to highlight here is in the slides you will see, and we'll go through the next several slides fairly quickly. You'll see a quick summary of federal registration, the exemptions conditions, so that you have something to look at and apply. It, of course, to John's earlier point, as a lawyer, I'm saying always read what the statute says, because there are conditions. There are essentially 9 thou shalt nots and thou shalts in the whole exemption, and they replaced the entire body of federal regulation of Wall Street investment banking firms that would have otherwise applied to everybody on this webinar. Because until this exemption was adopted to sell the securities of even a privately owned business, you would have to have been registered with the SEC, a member of FINRA, and you would have to have been registered in every state in which you were doing business, including where you're located and where your clients are located. We've managed to solve that federal problem. But you will see that we're turning now to the states because there is no federal preemption of state law in this context. And it is important as we move forward at the state level to try to maintain as much as possible consistency and uniformity with the federal exemption, especially state to state, because these days it's very common for a transaction to have a seller in one state, a buyer in another state, and you, the M&A intermediary, are located or have an office in yet another state. So you could have at least 3 states having jurisdiction. Every state's law is designed to protect the people who reside there, corporate and natural, and they're designed to regulate the people who do business in that state. So multiple states may have jurisdiction even in the same transaction. So coordinating among the state level efforts is really important. And we'll get to later in our discussion how state and regional M&A associations and chapters of associations can really facilitate that coordination. Next slide. So I'm going to highlight this just really, really quickly. This is for the audience to read more at your own time and effort. This is for private company M&A. It does not apply to public company, public offerings of publicly traded securities. There are size caps that are very generous and certainly were widely vetted within the industry before these were adopted. And there are alternate size caps because some businesses have high profits but low volume, and others have low profits but high volume. So these are alternate caps. And we'll leave the rest of this to you to read because I'd like to cover more around how do we proceed from here. Emily, next is key points here, though. I don't want to lose sight of the fact that pragmatically speaking, there are 3 requirements, 2 that would always apply and a third under some circumstances. And that is that the exemption applies when a buyer is going to take a controlling interest. That's presumed at 25%. It can involve more than just equity ownership. It can involve positions in the C-suite, can involve positions on the board of directors, but they also have to be actively involved in the operation of the business post-closing. Whole idea here is that the exemption's designed around the fact that, hey, if you're running the business that you're selling, or if you're buying a business that you're going to be running, then you have access to all the information that you need to make an informed business decision. And in fact, that's a selling point when talking to legislators or economic development folks about why this is important. It's that, hey, we don't need all the protections around passive owners selling or buying when they're going to be running the business. So they're informed. They often have a team of people that are going to run the business and lawyers and accountants. So those 2 conditions always apply. Acquiring a controlling interest and the buyer is going to be active post-closing. There's a third condition that applies in the event that a seller is being asked to roll over part of their investment, essentially reinvest some of their equity in a new form of security. And this can involve any number of legal structures, but essentially when you're exchanging equity ownership in the transaction and A common example of that might be for tax purposes, an F reorganization, where you're asking people to contribute their stock or their ownership equity interests into a new entity, and it will have different attributes than the existing business. And that's done for tax purposes, but for securities purposes, it's a securities transaction. So where the seller is being asked to reinvest in the buyer going forward, the regulators insisted upon having disclosure to the seller of what they're investing in. So it calls for existing the buyer's financial statements, P&L, current balance sheet, and some other things. And these three conditions are something that you can address up front, at least one and two out of the three, in your engagement letter. Say, this is my basis for a reasonable belief that the buyer you're going to sell the business to a buyer who's going to get a controlling interest, because maybe you're selling the whole thing, maybe you're selling all the way down to 25%. And to a buyer who's going to run the business afterwards. You can kind of CYA your reasonable basis in, for example, your engagement letter. So you may not know exactly what a buyer would do on a rollover or not, but there are other ways to document that. So anyway, these are key points about the exemption. And Emily, let's roll on to the next slide. There are some conditions here. I will highlight the one that would come up most commonly for IBBA members, and that is in a cash for assets sale, it's pretty common to have the M&A broker sort of serve as an escrow agent. That does not work if it's a securities transaction, because the exemption says thou shalt not have custody of the funds or securities to be exchanged in securities structured deals. Cash for assets, you're fine. But if it's going to involve a securities transaction, then you need to use a third-party escrow service so that you are, as the intermediary, not holding the kitty, the purse strings. Other examples listed here in the thou shalt nots are pretty straightforward. So, Emily, why don't you move on to the next one?
Sure. One thing I wanted to add too, in case everybody didn't see in the chat, that these slides, I'll send them out in a PDF after the presentation as well.
That's great. And I did see one question early on about Canada. We're only talking about US law here. I don't think this is an issue in Canada. Canada doesn't really have federal securities laws the way the US does. It's all provincial. And at least based on my anecdotal experience, I don't think the Canadian provinces have this issue. So the other thou shalt not is if you're disqualified here. The exemption basically says if you've been a bad boy or a bad girl, you can't rely on this exemption. So next slide. So turning to really what the heart of the issue is going forward, state level, where are we? As I said, we're up to 24 states, and it's really a combination of states where by lawmaking, and that'd be Florida. So all of the audience should not be totally apprehensive about, hey, we got to change our state's law or other states' laws. Florida did it. And Mike Ertl, to his credit, was the leader of the band for that. And they did it in one session with the Florida legislature, and it's actually been amended now. This says pending update, but they've amended it to tweak it, and they did it by lawmaking in Florida. So other states, rulemaking, this is a process that's a little different in every state. They all have administrative procedures for any agency's rulemaking. Usually involves public notice, public hearings, opportunities for comment. Rulemaking can be fairly tedious, and so quite often states will wait and collect several rulemaking projects and do them all at once. So they're a little slow, it seems, because it just takes a while for them to have accumulated enough reasons to engage in the whole administrative rulemaking process. So, but we do have, they're listed Alaska all the way through Vermont that have done it by rulemaking. And at a quick glance, I think South Carolina is now over in the rulemaking column instead of the order no action letter column. It hasn't changed the total, but I think South Carolina has moved over to the other column. The other list here is agency order, interpretation, or no action letter. These states have done it without going so far as to do rulemaking. The good and the bad is a no action letter is great if you can get it, except it's harder to make that enforceable federally, and it varies also at the state level. A no action letter is not legally binding on anybody. It's just an interpretive position by the agency that's issued it. So it's not as good as a legal rule, or for that matter, a law. No action letters are certainly helpful. They can be used to, hey, talk to the legislature to say, hey, the regulators have agreed with this. We ought to change our law to align with that. But the good news is we've got 23 states, and the last state is just an example, Washington, where they have an existing exemption that is not limited to M&A. It's all private placements. That's an unusual exemption in Washington state because private placements are the type of securities transactions where there are a lot of regulatory issues. But we got 24 done. We've got 26 to go, and the District of Columbia as well. So next slide, Emily, and we'll talk a little bit more about how you, our participants in this webinar, and your colleagues can make a difference. You really want to work through as much as possible your state and regional associations. And I say that again to emphasize that getting the same exemption in all the states that aligns with the federal exemption is really important. And if you go off and try to do it one-off by yourself, there's a very real risk that you will miss something. It will be a little different. And then the requirements in one state, let's say New Jersey, might be different than the adjacent state of New York. And so it really is important to try to coordinate this among the state and regional associations. And in doing that, there's strength in numbers, because what you want to do to kind of lay the groundwork, create a little bit of a mini plan, is identify who your allies are. State economic development advocates very much on your side, because you can argue very effectively that, hey, if a business is going to be a choice between somebody's retiring and they're just going to shut the business down and go home, or, I mean, those jobs are lost. But if they sell the business and it gets combined with somebody else or a new operator owner, now you've preserved those jobs. And so that is a really, really good talking point to the state economic development folks, because the M&A transaction preserves jobs. And in fact, in some instances, can combine a couple smaller businesses or a small business with a larger one to actually make a stronger competitor that is better able to compete and preserve those jobs. You want to identify, besides advocates, development agencies in the state. I think all 50 states have some form of economic development agency, often in the governor's office, whether it's directly or indirectly. Identify who the leadership is in those agencies and advocacies, but by all means, try to coordinate these efforts, because uniformity really becomes important. And in that mode, bear in mind that NASA, the North American Securities Administrators Association, has this model rule that was just updated in 2024 to align almost perfectly with the federal statutory exemption. And you can go to the economic development advocates, the governor's office, the legislature, and say, look, the State Regulators Association has promulgated this model rule, and we should follow it. And we should stick to it because we don't want, some imprimatur, wordsmithing. Somebody wants to say it a little differently because we can say it better, because they will say it differently, and that's not good. You want to have consistency. And the model rule both gives you the sort of force behind having other regulators say, hey, this is a good idea, but also you have a very consistent work product from the legislature or from the state agency to be able to say, let's stick to the way it was written, because it needs to be the same in all 50 states and DC. The other way you can help, and I will give a little pitch here for John and Beef, is you can contribute to this effort. There's a place on the internet here on Beef's website that you can use to make a contribution to help fund this effort. So, Emily, you want to?
Interject a little bit there?
Yeah.
Just for clarity, a couple items. We have a number of states that we've solved the problem. They have solved the problem. We have a lot of states that aren't. There's a lot of questions that have come up here, which we'll start going through now. But one key item I wanted to make sure I communicate, and Shane, correct me if I'm wrong, but our goal is to try to find boots on the ground in each state, be it associations, a firm, an individual, because they want local individuals. They want their constituents being involved in any change or adoption to this federal law, as well as this now profound state approved, ruling. So I just wanted to throw that out there. I mean, that's really the key. Now, there's some good questions that have come up here. I want to make sure we hit as many as we can, because there's a ton in here, Shane, and I'm going to throw them at you.
You can do that, because you can read them better than I can.
I'm looking at them right here. A couple of things. I'm a licensed realtor. I'm a licensed real estate appraiser. I do consulting for doctors. And my doctors want to expand through mergers and acquisitions. Do I need to have a license? Does this impact me?
It absolutely impacts you, because it really depends on the legal structure of the transaction. Like I said, 17 states, and not really part of the content of this webinar, 17 states regulate business brokerage services under real estate licensing laws, or Illinois is an example where it's not difficult. You have to annually apply for a license in Illinois. But California requires a real estate license to sell what's characterized as a business opportunity. So number one, you need to check your state and to see how your state regulates the business of business brokerage, because you live there, you work there, you're conducting business there. If you have more than one office, and so you have offices in multiple states, now you're conducting business in multiple states. Well, so now you have a seller client who's in yet a different state, and a buyer who is in, a third or fourth state. And the answer there is that multiple states can have jurisdiction, and you really have to solve the problem in each of the states. So if you're in California and you're selling a doctor's practice in Nevada to somebody that's headquartered and conducting business in New Mexico, all three states' laws probably apply and will apply to the parties conducting the transaction, because you are doing business in those states by virtue of having clients or counterparties in those states.
Interesting. I have it from another note here on our webinar today that California within California allows a securities transaction if it's an asset sale that turns into a stock sale. And it must be for all of the company with no other limits or guidelines. Are you familiar at all with that, Shane?
I am, and you are correct that as a licensed broker dealer, somebody that is regulated by the SEC and FINRA and the states in which they do business in California, in this instance, California says it has a carve out that allows you to do that transaction through the broker dealer, not individually. It's got to go through the broker dealer. Broker dealer has to be on the engagement, and it is limited. It's limited to selling the entire business. It is not any fractional ownership interest of that. So to do that, you have to have a securities license with the broker dealer, and it's licensed through FINRA and through the states. So California is actually, as they say, a hot mess because there are in California some reasons that you'd want to do the transaction through a broker dealer. Because if you don't, then you have to have the California real estate and business brokerage license. So California is why this is a good example of the nuance and complexity of the whole thing.
Interesting. Another question that's come up a couple times here from folks, and you kind of answered it. It's not just the state where the business is or the state where the services are rendered. It could be the states where buyers come from. Is that what I heard you say?
Well, because you are rendering, if you're the intermediary, you are conducting business on behalf of either the seller or the buyer, but you're conducting business, sending communications to and meeting with the counterparty, whether it's the seller or the buyer. And state laws are designed to protect the corporate and natural citizens that are located in a state. And so you might be in California, but if the buyer or your client is in Nevada and your seller is in Nevada, buyer is in New Mexico, now you have parties in all three states, and all three states' laws would have jurisdiction. That's where it gets complicated, and that's why coordination and consistency and uniformity among the states is really important.
Is important. A good question from a good friend of mine. I recognize in Canada they can do securities transaction, but he asked, what happens if I have a Canadian firm that I'm a Canadian firm, let's say, and I'm brokering a business in the U.S. and it's a securities transaction. Do I have to be licensed in the U.S. then?
Absolutely. You're doing business in the U.S.
How about Canadians?
Doesn't matter. You're electing to do business in the U.S. and in whatever state your seller or buyers are located. So you're subject to the jurisdiction. By the way, you're probably also subject to U.S. income tax.
Didn't think about that. Let's not go into that question.
Also subject to the jurisdiction of U.S. courts, federal and state.
True. A few other questions. I'm just trying to bounce between them because there's some consistency in the questions. There are some states that have exemptions to sell businesses if they have real estate licenses. How does that impact securities licenses? And if they get the securities exemption in that state, do they have to have a real estate license to sell a business? How do they navigate that? How do they figure that out?
It's actually pretty simple. The answer is there is very little harmonization between securities regulation and real estate and business brokerage licensing. Two separate laws. California, I've already mentioned, does have this kind of accommodation to say if you're a registered and regulated broker-dealer, you can do a transaction without having a real estate license. But by the way, that's only for a securities transaction. It would not apply in a cash for assets transaction. It doesn't involve securities. So each of these licensing regimes, whether it's securities regulation or real estate and business brokerage regulation, They are each separate professional licensing regimes, and there is very little harmonization of them. So you very likely have to have both. There are a few exceptions, California being one of them, and there are a few other states that are maybe similar, but they would all require you to do the deal through the registered broker dealer. And you'd have to have the individual licenses to do that, and you'd have to be registered and regulated through that broker dealer. So it's not a good solution, is the short answer.
Let's say I'm an intermediary in New York City,
Mhm.
and I sell a business, and it has an earnout for a third of the purchase price. Uh, and I get paid if the seller gets paid. Is that a securities?
It can be.
Okay.
The SEC has published an interpretate the staff have published an interpretation about when an earnout is or is not a security. It's very fact dependent, but in a nutshell, an earnout that is characterized as essentially a price adjustment, and it's tied closely to the sale of the business. And it is not, most importantly, it is non-assignable, so it can't be separated from the party who sold the business.
Hmm.
Because if it were assigned to somebody else, it becomes an investment by a passive investor, and that's absolutely a security. So earnouts in general, I would say most corporate M&A lawyers draft pretty good documents to say this is not assignable, the earnout or the purchase and sale agreement, the transaction definitive documents don't allow assignment. And so I would say in general, typically not, but it's a fact question, and the SEC's guidance around what, when, and when not an earnout can be a security actually prompted the SEC staff to issue some guidance around that.
I know you mentioned F reorgs, which is very common in my world of private equity groups and transactions right now. It's a very efficient tool. Um, does just having an F reorg and me being a broker in New York City in itself become a security?
Well, regardless of what state you're in, whenever you're exchanging an equity ownership interest as opposed to cash,
Mm-hmm.
you're exchanging an equity ownership interest for a different equity ownership interest. The characteristics of that equity ownership will be different. At the very least, it'll be a different entity.
Hmm.
The rights and interests of all of the owners of that entity will be different because by definition, you're being acquired or you're selling. And so the business that's being sold and absorbed or in some way combined will be changing as a result. And so the question becomes, do you need the protections of federal and state securities laws? And the regulators would all say yes, that in most instances, if you're exchanging equity, it is not cash for assets anymore. It is now a change of equity ownership. And in that scenario, it is almost certainly a securities transaction.
Hmm. Does this regulation, this exemption, have any limitation on the engagement agreement's length of engagement? That was one of the questions.
Length as in duration, or the how many words the lawyers wrote and how many pages long it is. I'm just being facetious. The answer is, I think the question is how long can you bake into your engagement letter expectations of your reasonable belief about what the transaction structure is. And I'll start with the premise to tie back my earlier comments is engagement letters are a great place to kind of lay out what your reasonable belief about the transaction structure could be.
Hmm.
May not be. It may turn out to be something different. but then you can document your reasonable belief in other ways, not least of which in the final transaction documents. So don't feel like you're boxed in by your engagement letter. It's simply one way of demonstrating in an engagement letter that is signed by your client, that the expectation is that it's going to qualify for this exemption. It can obviously morph. About half my career I did bank M&A work, and I know M&A transactions can take all different forms, forks in the road, and so you really have to preserve flexibility. But in this instance, we're just trying to demonstrate a reasonable basis for why you think you don't have to be registered as or with a SEC and FINRA regulated broker dealer. So the engagement letter is a good way to do that, but other documents can do that as well. The duration in the length of time for an engagement, this is probably more relevant to on the buy side. The sell side, you're going to sell the business. It may take a few years, but you're going to define how long the engagement is. Most client sellers are going to, and their lawyers are going to say, this is maybe continuing for a couple of years, but we reserve the right to terminate it at some point. It may have a tail, so that they protect their investment of time and effort in prepping a business for sale, and having some reasonable amount of time to complete the sale. But I would say in my experience that open-ended engagement letters are pretty uncommon, with the exception maybe being on a buy side where deal flow is all important and you really want deal flow. And so you may have an engagement on behalf of a buyer in providing that deal flow. Although even there, I'd really recommend you have a supplement to kind of tie it together to say, okay, we have this ongoing engagement letter to buy business, help you find and buy businesses, but we're going to tie this together with a little letter supplementing it to say this XYZ Inc. is going to be subject to, most importantly, the compensation arrangement for the buy side engagement. Does that make sense?
It does. It does. That's interesting. A number of other questions here, and I'm just trying to pick through them, and I don't understand this question. So this individual wants to add more detail. What do you know about DSO and MSO requirements?
DSO. I would think DSO is the Detroit Symphony Orchestra, of course. I don't know the answer to what those acronyms are.
I don't either, and I didn't want to start typing on my, hang on, it's Managed Service Organizations.
Okay. Well, I think conceptually what you're asking is the type of business and how it is operated. And I think that the type of M&A transactions legal structure will, in some instances, be pretty typical. So I'll describe it this way. A dentist practice or a medical practice, some sort of financial services practice. Quite commonly, it's a service business. So there really isn't a corporate entity being purchased. It really is an asset transaction. Now, the question is, what else is being exchanged? Is it cash for those assets? That's probably not a security. But on the other hand, if there's some patents involved, or some other reason the corporate entity of the seller is important to the value of the business, could be long-term contracts, it could be patents, it could be things that can't readily be sold, or in a very large business, there's just too many assets to try to do it effectively. In those transactions, it'd be more common to sell the entity rather than its various assets. So I would say and another example might be radio stations, TV stations, where your FCC licensing is really tied to the entity, where you really probably want to buy the entity. But I'll give you an example in contrast. For all of the years of bank M&A that I did, banks acquire other banks. They don't need the license. They just absorb, the deposits and the loans into their existing bank. So there it's a regulated entity, but they already have the licensing and that they need. So it's less important. So short answer is it varies, I think, by industry. But the core question is, are we selling assets for cash? That's just as black and white as you can get. You can add lots of facts and circumstances that make it much more complex in terms of the deal terms and what's actually being transferred.
So what I hear you saying is an MSO or a DSO, which is a dental service organization. If it's sold as an entity for its customer base, it's the securities deal.
Yep.
They're buying chairs and hoping to get their customers. That would
And
be
a
an
client
asset.
list.
Yeah.
Yeah, it's the client. The client list is an asset, but if you're buying the entity that arguably owns it,
Right.
then it's an equity ownership transaction as opposed to an asset transaction.
Great questions, folks. And there's a number of questions yet. We may not be able to get to all of them here today. But once again, another common thread. These other states that have not yet adopted this principle that has been changed in federal law. What states are in the process of communication with you and are making some headway at this point?
Yeah, we have communicated with literally all 50 states and the District of Columbia and the U.S. Virgin Islands, Guam, and Puerto Rico, too, if that matters. We've sent letters to them all.
That's good to hear.
We've sent letters to them all, and actually, the letter included sort of a 3 or 4 question response from the regulators to say, "Are you considering this? Would you consider it? Can we help you in doing rulemaking or whatever to adopt the exemptive relief that the NASA model rule provides for?" And I think I got answers from about 6 of the states, all of which were supportive. Several of the states said, and Wisconsin would be a great example. I know it's a nearby state to Michigan. I know the people involved. I actually think highly of them. Their answer was, we have a very complex process for rulemaking in Wisconsin and true in some of these other states. And we will get to it, but we will get to it when we have enough other rulemaking to warrant, to justify the public notice, the public comment period, publication requirements. Michigan, which is already in the win column, but Michigan even has to get the legislators involved to essentially not reject rulemaking for it to become effective in Michigan. So I'd say there's probably a half a dozen states that have not yet adopted the model rule, but are anticipating it. And, frankly, that's just a good reason to reach out to those 26 states and say, hey, this should be a priority for you because 24 states have already done it. And the federal government has already been changed. Federal law has already been changed. And even your state regulators association, NASA, has adopted a model rule covering it. So where are you? You want to encourage them to make it a priority to reach out to them. And for everybody on the call, if you would like a copy of the letter that went to your specific state, it's available. We'll send it to you. And it was sent in 24 after NASA had updated its model rule. And it's a pretty good starting point to say, hey, look, federal law changed. Other states have adopted this. It's a model rule. And you really need to adopt the model rule. Don't tinker with it. It needs to be the same in all 50 states, or at least pretty close.
To wrap up in the last 3 minutes that we have, I just would like to share with everybody that BEEF, as well as the IBBA, the M&A source, and many other professionals are still working towards getting these other states aligned. Each state is different, and Beef has invested in legal, Shane Hansen, to help different state members navigate these waters if they would like to reach out to their representatives. We have kind of a kit put together, but the kit has to be custom per state, depending on how their process occurred. So I would encourage all of you, if you have interest in being legal in what you do in your transactions and doing the best you can for your sellers in a tax efficient methodology, even, and not alone operational, I would definitely take Beef up on this. Reach out to myself, Shane. Probably be best to reach out to myself or the IBBA or an M&A source, so we can kind of herd everyone together to be efficient. But once again, I'd be very careful, and I'd encourage you to participate. It only takes one person in a state to make a difference. It took two in Colorado, Ron Chernak and myself. We changed Colorado, two people. So it was something that we were very proud of. Thank you
And
very
John,
much.
I would just add also to be proud of, and an important mechanism here, there's among the state and regional associations, periodic calls, conference calls that can connect the leadership in these state and regional associations. And so you can share your experience on these calls, and they could be arranged. John and I are available to join a call like that. So sharing experience, and hey, the state next door to us has adopted this, so we should too, is
very regional, you're right.
Yeah, it's important. And so coordination among the associations, because you definitely have more clout when you have letterhead behind you, when you're reaching out to the governor's office or the legislature. And it does remind me of a point I didn't make, and that was also sometimes it's just a push that is needed. The state regulators, they're state employees. They don't go out on a limb very often.
It's a nudge.
It's a nudge.
Anyway, we've come to our time limit here. Let me turn this back over to Emily.
There you go.
Perfect. Well, and I do encourage people, because there were some questions coming in where I can find these lists, how I can get access to it. We're going to send out the slides, but also Beef has a great website. And I know on the IBBA in our resource tab, you'll find our legal updates. And there you can find some of those lists, some of those resources available to you regionally. If you're a member of one of our regional groups, CAB, TAB, CVBBA, these groups are already kind of working towards this together and bringing everyone together. There's more. I apologize if I didn't mention it, but I do encourage you to reach out and share your stories. This recording will be available on the IBBA and the M&A Source website. Again, under that resource tab, under our legal updates, we'll have them there for you, as well as John's contact information if you are interested in learning more. And I just want to add, thank you guys so much. What an amazing panel. And getting these updates at the state level is really important to keep everybody safe and legal at this point. So.
Thank you, Emily. And thank you for bringing us together.
Yeah,
my pleasure. Take care. Thank you.
Bye-bye.
Bye.